Good evening, everybody. Just going to get started here in just a moment, giving folks a minute to hop on. As a reminder, if you are at your computer, we highly recommend clicking the link to join the video. You'll be able to see us through the program that we're calling Zoom. I'm sure many of us are familiar with Zoom at this point. And just as a reminder, we will email around the recording to everyone who signed up in the beginning. So don't worry if you can't stay for the entire duration, but we highly recommend it because this is going to be a really exciting evening. Alrighty, welcome everyone to the webinar, Fracking and Zoning. I'm Robin Martin, an Allegheny County organizer with Food and Water Watch and Food and Water Action. And like I said before, we have a fantastic lineup of speakers tonight. Thank you so much for being with us. Just before we get started, I would like to reiterate just a quick orientation if you're joining us on Zoom. We will be here on video and you'll be able to see all of the speakers as they share if you click the link that you received in your email. But don't worry, we can't see you, so kick back and relax. We will be keeping everyone on mute to cut down on background noise. If you have a question at any point in the presentation, you can click the Q&A button at the bottom of the screen, and we'll get to those as many as we can throughout and during the end of the webinar. We are starting with the questions that you wrote when you RSVP'd, so bear with us as we try to answer the most asked ones first. I'll also note that we will not be using the raise hand button at the bottom of the screen. So once again, please make sure that you click Q&A if you want to ask a question. If you have any technical issues at any point, or if you're joining us over the phone and have any questions, please just email me at rmartin@fwwatch.org. And with that, let's get started. Fracking can occur in any community regardless of size or areas. Many municipalities feel that there is not much that they can do to protect their community, but in fact, there are many options that can be individually tailored to fit the needs of their community. We are so proud to be joined this Monday evening by an all-star lineup of experts in their fields to bring you a comprehensive look at how you can make sure your community is adequately providing the health and safety and welfare of its citizens in this domain. But first, just let me give a brief background on Food and Water Watch, as well as introducing my colleague, Doug Shields. Here at Food and Water Watch, we are a national organization that has been hard at work over the last 15 years to create a healthy future for all people and generations to come, a world where everyone has food that they can trust, clean drinking water, and a livable climate. Making this happen requires involving people in many of the pressing issues of our time at the local, state, and federal level, building on one win after another as we develop a larger movement that has the political power to make a democratic process work. In Southwestern PA, we have expanded our team through our Municipal Ordinance project. This is a project that is unique for our organization, but very much necessary here in Southwestern Pennsylvania. I am so proud to introduce to you our Southwest team member, Douglas Shields, our Western Pennsylvania outreach liaison, who will be moderating portions of tonight's webinar. And with that being said, I will turn this over to Doug Shields, who will talk more about what the Municipal Ordinance Project does. All right, Doug?
Hi, and welcome everybody, and thank you for coming tonight to attend this evening's webinar. And those of you that joined us last Saturday morning, thank you very much, and I hope everybody had a happy Father's Day. I'd like to show you a few slides before we begin today's program with noted attorneys, Solicitor John Smith and Professor John Dernbach. I'm trying to see where my slides are now. Pardon me if I get my little technical difficulties. There we go. We're getting them up now. Thank you. Appreciate that. And we're there. Great. And then Robin, if you can hit the button when I say hit the button, we'll move to the slide. So this is a great picture, and I love showing it. I got it from a good friend at Frack Tracker Alliance. This, believe it or not, is Versailles, Pennsylvania in 1920. This is what happens to a neighborhood when your municipality doesn't have a good zoning code or a comprehensive plan. As you can see, industrial and residential land uses are mixed together and aren't what you might call an ideal situation with compatible uses in the same place. In other words, houses being with houses, wells being with wells in the industrial zones, and residential for homes and things like that. That's what zoning's all about. It's about putting like things in the same district or area or zoning district, and that way you don't have conflicts. And of course, back in those days, Well, that was back in the days. Industry did what it wanted. And today we have a more enlightened approach, and you can put the next slide, with modern zoning codes to prevent incompatible land uses, or do we? As you can see, this is a picture of a place down in Texas, and it kind of looks a little bit like Versailles in 1920, and that's been a real problem with planning for unconventional drilling here in Pennsylvania as well. As you may know, and we'll get into this tonight, the state legislature, in its infinite wisdom, passed the Act 13, and in it, they took the bat out of the local officials' hand and the community's hand as well, and basically said that the oil and gas industry exclusively has a use by right in all zoning districts of the Commonwealth. And basically every square inch of Pennsylvania under that provision of the law opened it up for drilling for everybody, and we can all go home and not have to worry about these things. And again, here's another community in Colorado. Again, an industrial use sitting amongst a residential district. And, you know, obviously that was not something that we call compatible. The proximity of that well to these residences also exposes them to toxics, possible fire, explosion, and so on and so forth. So we have come a long way with zoning codes that all of a sudden the oil and gas industry felt that they were special, and while the United States Steel can't build a steel mill in the residential district, they can put a well anywhere they want it. And we'll get into that a little bit. Next slide, please. And as you can see, Allegheny County is home to 1.2 million people, and the county itself is sitting right here. You can see Pittsburgh, that's Allegheny County, and it is surrounded in a sea of gas wells that are slowly encroaching upon the county's more densely populated communities. And this recently updated frac tracker map that was illustrating this land use shows how this works. The purple dots are the wells. There's probably over 21,000 wells in Pennsylvania now, unconventional. And this recently was also done. The yellow indicates violations, and the green dots are the compressor stations. It's another thing we need to plan for as well, and other midstream infrastructure that is common with unconventional drilling. While regulations are in place, they seem to have a hard time with compliance nonetheless, based on all those yellow dots sitting on top of all the purple dots where the wells are. So violations are part and parcel of the industry. And if you go to the next slide, please. Thank you. And so the Municipal Ordinance project was developed to help Allegheny County's residents and municipal governments to prepare for unconventional shale gas extraction, commonly known as fracking. The Municipal Ordinance project we started in 2016, 2017 over the winter, and yours truly read about 105 of the 130 Allegheny County municipal zoning codes. And the results were rather shocking. More than 20 years after the first unconventional well was drilled here in southwestern Pennsylvania, over 50 municipalities in Allegheny County don't have a zoning ordinance on the books to govern where fracking takes place. Other municipal codes are woefully outdated or non-compliant with current state law. In 2009, the courts ruled that the local governments have the exclusive right to decide where fracking and its related operations may occur within their municipalities. And this is done with local zoning ordinances. Unfortunately, many Allegheny County communities have not taken appropriate action to protect themselves from fracking and related uses. And so, what does the MOP do, the municipal ordinance? First, we identify the county municipalities that don't have the appropriate ordinances and go from there. Then we engage with local government directly and their citizens of these municipalities to enact ordinances that are protective of the community of the whole by limiting the scope of adverse health and safety impacts caused by drilling. And we organize. Local citizens become effective advocates when we give them the tools. We can't come in and say to the council, hey, you should do what we say. What we do is we work with the council, citizens alike, educate people, bring authoritative sources of information, good solid information, and then we give everybody the tools to begin to make the changes that they're going to have to make. So next slide, please. Things to look for. Well, when we go looking for things in your municipality, but now we're working toward into the South Hills of Allegheny County, we look and see if there's an industrial zone. Is there in fact a place to place an industrial use in this municipality? And I will tell you this, 40 municipalities in Allegheny County are under a square mile. Most of those don't have an industrial zone. There isn't going to be enough of a setback if there was anyway. And it is very problematic, and we'll get into that later this evening about how you deal with that when you don't have a place for fracking in your community. Conditional use in all zoning districts. This is another big problem. Conditional use is a special exception, a way to allow a use that isn't normally allowed in a, say, a residential district. However, a lot of municipalities that we reviewed, North Fayette Township, Bethel Park, they allow conditional use in all zoning districts of the borough for oil and gas extraction. And that's certainly not appropriate. And none of these municipalities I noted didn't have a conditional use for steel mills or nuclear power plants in all zoning districts either. But somehow or another, they feel that, you know, and a lot of these codes, by the way, are very old and pretty much outdated. The oil and gas codes that we've looked at were obviously written in the 50s and 60s in some cases. Then we look at a setback. Is there an appropriate setback for a well? And we have found that in many cases there is not. Currently, the setback minimum set by the state is 500 feet, but there are municipalities that have setbacks at up to 3,000 feet, and they have not been sued, they've not been challenged in court, and what they're looking for is to protect the communities, and that's their primary responsibility at the local level. Do you have a seismic survey ordinance? That's another part of the process of looking for oil and gas, or in this case, shale gas in Pennsylvania, and where you're taking a geological MRI of the subsurface to determine the best places to drill. To do that, you have to use the public right-of-way. Now, when you put a dumpster on the public right-of-way in your municipality, you probably get a permit or something to use that right-of-way. Many municipalities have no ordinances governing the use of the public right-of-way, where what they call thumper trucks send down strong vibrations into the ground. They're recorded and they bring back an echo. We have seen instances where that activity has caused property damage. We also have found court cases wherein companies that didn't seek permission to get the data under your house were sued for seismic trespass. And there is case law on that, believe it or not. So you need to have an ordinance. In the injection well ordinance, again, a cautionary tale. In Plum Borough, they got an injection well because they did not account for it in their code, and it automatically defaulted as a conditional use into the whole of the community. Important to have that piece in there, and we'll have the elected officials videos available for you that didn't see it, and David Venta, the councilman from Plum Borough, gave a great review of that on Saturday and what can happen. How about, do you have a use default table clause for unlisted uses? What that goes to the injection well. If you have a default clause that says if the use is not listed, then you automatically default to a zone as a conditional use or something like that. And that way the municipality now has some measure of control on what's going on, and who the heck knows what all the uses could possibly be. So no one's ever going to list every use under the sun, but if you have a default clause, it works. If you don't, you got a problem. Public lands that may be leased. How much public land is available in your community? And this has been an issue in a number of places. Last year in Franklin Park was about ready to lease 80-acre community park. It was all subsurface. There was going to be no drilling in the park. The wells would be located right over the border in Economy Borough. And of course, the public reacted strongly to that, and the council voted down the potential for lease. But you might want to find out what these lands held in common, what their status are. Are they already leased? Could they be leased? And the Borough of Emsworth, by the way, passed an ordinance, I believe in 2011, that stated that, you know, the public lands in the Borough of Emsworth are not available for leasing for any purpose, such as drilling. So that's there, and that's something you should think about as well. And then again, the language in the conditional use exception itself. The devil is always in the details. And to give you an example, South Fayette Township, which is a very strong ordinance there, has a 23-page conditional use language. Keep turning the slide, Rob. One more. And okay, so we're going into, we have worked throughout Allegheny County, in the Quaker Valley, in the North Hills, out in the eastern parts of Monroeville, Oakmont, and Plum. And now we're beginning our effort to begin to go into the southern neighborhoods of Allegheny County. Well, where is that? Let's show the next slide. And we're talking about Bethel Park, Brentwood, Bridgeville, Castle Shannon, Collier, Heidelberg, all these areas here, South Park, Upper St. Clair, and so forth. And we've worked this little matrix out here as we called it our report card. And as you can see, let's look at Bethel Park. They have a conditional use exception, but unfortunately, we run into a problem with a slide. Why don't you bring it back to that other matrix slide? Oh, okay, we got that one. Thank you, Robin. Do they have a conditional use? Yes, except it's not restricted to an industrial zone. It's allowed in every district of the borough. That's not appropriate. You wouldn't allow a diesel mechanic shop in every district of the borough, and so why would you allow an industrial use that way? A lot of this is a hangover from the old days when conventional drilling was around, and nobody seemed to mind having a conventional well in the backyard or over the hill or wherever. But as we all know, unconventional drilling is a far and a more way impactful land use. So that it's drilling on steroids. So do you have safe setbacks? Well, in Bethel Park, no, they didn't. In fact, I think it was around 200 feet, and the state minimum's 5, and yet we're looking at scientific evidence that University of Maryland suggests at least 1,000 feet to protect from fire explosion. Other studies have came out. The notable University of Chicago and Yale University study indicated that up to half a mile away, you're seeing adverse impacts to children, reproductive health, low birth weights, and so forth. So what is the safe setback for you? And is it based on science rather than a coin toss and saying, well, let's make it 500, let's make it 1,000? Based on what? Who knows? Whatever was on your mind that day. Do you have a 10-year master plan for drilling? No, they didn't. And neither do a lot of other people. And just so you know that every 10 years, a municipality is supposed to develop a comprehensive plan. This would coincide with that. If you get a conditional use, there's more than just a well pad coming into the borough. With a well pad, it's connected to a lot of other things. And you want to know as a municipality what that total build out is going to be over a 10-year period. Are there going to be frac ponds there? Are there going to be pipelines, temporary or permanent? Are there going to be other infrastructure facilities like compressor stations, pig launchers, cryogenic plants to separate wet gas from dry gas? What's it going to do? When we have a McDonald's or a shopping plaza come in, we all kind of understand how it interacts with the rest of the community. Maybe if you're going to put a strip mall up, maybe you're going to have to put a street traffic signal in to manage the new traffic. Here, what is your plan to deal with all these things that are going to be coming in with the use associated with unconventional drilling? Do you have an injection well ordinance? Well, they'll never have one of those here, right? Well, that's what they said in Plum Borough. They have an injection well. So you're best off to have an injection well ordinance that governs that use. That's your right as a local government. For those of you in local government watching, that is up to you to decide where these things go. Not the state, not the DEP, not the federal government. It's always up to the local official in the zoning context. And do you have a seismic survey ordinance? You want a bunch of thumper trucks coming into your town and they go, well, we're just coming through and you can't do anything about it. That's about almost what happened in Oakmont. And that council reacted very quickly. And within 4 weeks, they had a new seismic survey ordinance on the books. Robert, let's go back to Oakmont again. This is a great slide. We worked really hard. It was our first effort in Oakmont. They got a seismic survey ordinance, and then we went on to show them the problem with their zoning code. And this was their conditional use exception for oil and gas in the borough of Oakmont, which is about 1.5 miles square. And basically, the language is very vague. Compare that to the explicit language in 23 pages in South Fayette Township and other municipalities that have kind of followed suit in that one. But important words like, if you see the one in red, the site plan shall reflect landscaping adequately so as to screen and buffer neighboring projects. Well, how's that going to screen and buffer neighboring properties? That's a very vague, a very broad statement that isn't explicit, and it's going to be hard to enforce. They also say things like, well, production must be located a sufficient distance from inhabited structures. Well, sufficient isn't a number, and then it becomes, okay, well, what's sufficient? So when a court looks at something like this, and they're going to say, well, what's sufficient? You should have a number there. And then also, in no event, be located 200 feet. Well, we know that's not legal anymore. Even the state law prohibits that. So you need to, brush up your zoning code a little bit and see what's going on. But one of my favorite pieces of this, and much to the shock of some of the council members in Oakmont, was when we pointed out, you allow drilling in the residential 1, where the big houses are, and 2, where the less big houses shall be limited exclusively to public parks. So what Oakmont was doing in this old code, probably written in the late 50s, 60s, and designed for conventional drilling, is that they're saying you can drill in residential districts, but only in the parks. So I asked them, where are the kids going to play? And they go out in the street with a bicycle and get hit with a water truck or something. Next slide. So that's an old ordinance. So what are you going to do? It's up to you, folks, whether it's the elected official who's watching tonight, whether it's the citizen that's concerned about this, and whether you're in the South Hills or not. What can you do? Well, we're here to help. The Municipal Ordinance Project is going to help you get involved with your local government, and you need to sit down and talk to your representative. As a former elected official in the Pittsburgh City Council, I was quite aware of the fact that I didn't rule my constituents by fiat. I represented their interests, and it was very important to start a dialogue with your constituents. And just the same, it's very important for the electors, the people, to start a dialogue with their local officials too. It's not exactly the most exciting thing to do on every night, but it can get exciting at times. Meet with your local official, ask questions, and we have the questions to ask for you too. Determine if your town is ready to host oil and gas extraction. Are you prepared? Is your public safety people okay? Are they up to speed on this? I mean, there's a host of things that we have to deal with. The other thing is to organize. Host a community meeting. We'll come now by way of Zoom because of the pandemic, but there's all kinds of ways for us to communicate, get together informally like we're doing right now, and to have that discussion. Bring your local official with you. Just chat over a cup of coffee. How can we make our community better? How can we protect it? And if you don't know how to organize, believe me, we do, we can help. So if you need any information, go ahead and contact us, Robin Martin, as you can see the email here, or myself, and we'll be happy to work with you and your local governments to do this. And one other thing is a lot of people are afraid about getting sued. And I will say that Municipal Ordinance Project has a very important credo. We don't work with the law. We only work with the laws that are already on the books, not the ones that aren't. And what we do is we promote legal, enforceable zoning codes and other ordinances that municipalities can use to lessen the impact of unconventional drilling in their communities and protect the public safety and abide by the Constitution of Pennsylvania and the Environmental Rights Amendment at Article 1, Section 27. So there you go. And Robin, did I miss anything here? Let's see, can I have a next slide? Oh, somebody, where on the slide? I guess, am I okay? There we go. We're going to work it out right now. Thank you, Robin. So that concludes a little commercial about the Municipal Ordinance Project, what we do. And we're very proud tonight to welcome our panelists. And Robin, I believe you'll be introducing our first panel of legal experts. Is that correct?
I'm very happy to do so.
Thank you. And I'll step off the stage for a moment.
All righty. Actually, Doug, can you check in real quick? My computer is freezing. Oh, Doug, you're muted.
Thank you. There we go. First up, I'll do the introduction since we got a little problem on our technical side. But John Smith is a municipal solicitor, and I'm trying to get to my note on that. Give me a second, pardon me. There we are. And John Smith, some of you have heard of, is a whole chapter devoted to him. There's John, welcome. John Smith is a co-founder of the law firm of Smith Butts Law in Washington County, Pennsylvania. He focuses his practice on areas of commercial and construction litigation, but also has a very long and amazing experience in working with oil and gas interests here and so forth. John was the lead attorney along with Jonathan Kamen and Jordan Yeager, who successfully argued before the Pennsylvania Supreme Court on behalf of Pennsylvania local municipalities in the landmark case Robinson Township versus Commonwealth. And as a result, the Pennsylvania Supreme Court found several provisions, I think about 9 is my count, maybe 7, 8, 9, somewhere in there.
There were a lot.
There were a lot. There's at least 9 provisions of that state law that was passed by our state legislature that were shockingly unconstitutional, not the least of which was the use by right in all zoning districts for oil and gas only. He also was featured in Pennsylvania's Best Lawyers, and also he is also featured prominently in a whole chapter of the Pulitzer Prize winning book by Eliza Griswold, Amity and Prosperity. The chapter title is called Mr. and Mrs. Atticus Finch. Came from me. I didn't get any royalty for that, John, but thank you.
I know.
And John's been through the ringer with oil and gas, and I'm sure we're going to find out an awful lot about what goes on in your zoning. And then with us tonight is my honor to introduce to you Professor John Dernbach of Widener University Commonwealth Law School. And John is a nationally and internationally recognized authority on sustainable development, climate change, environmental law, and he's also the director of the Environmental Law and Sustainability Center and brings his expertise into the classroom in courses on property, environmental law, international law, and sustainability. He's written over 50 articles for law reviews and peer-reviewed journals and authored and co-authored and contributed chapters to more than 20 books. I also took great note that in recent PA Supreme Court decisions, particularly Justice Castile cited Professor Dernbach several times, and he was in Robinson Township case in 2013. And gave it a plurality decision in the I'm sorry, can I get that messed up? That was a plurality decision in Robinson that was later then adopted by the Supreme Court and now is the law of the land. And he's also done a lot to reinvigorate the Environmental Rights Amendment in our Constitution, which we'll hear about. And until those decisions, the amendment, which recognizes the basic rights of Pennsylvania citizens to a clean environment, had been nearly dormant for more than 40 years. And so we're really happy to have both of you gentlemen on tonight. And let's start this off with, I guess, John, we talked about this earlier. I'm going to refer to John as Solicitor Smith and John Dernbach as Professor Dernbach, so that we don't get mixed up on our John stuff. John Smith, how are you?
Doing well, Doug. Thanks for having us. You did a wonderful job introducing our issues. And I know you've been involved for years, so thank you for that, because you make our job easier.
We're trying. And you have a brief presentation prepared for us this evening, I believe.
And Professor Dernbach's going to start this and
go over
Article 1, Section 27.
Great. Go ahead, Professor Dernbach. And everybody get your notepads out and start taking notes. You're going to school.
Well, thank you, Doug, for the kind introduction. It's a pleasure to be part of this. What I want to try and do in just a very few minutes is give you a basic outline of what Article 1, Section 27 is about. It's easy to understand, but it's also easy to misunderstand. A starting point, at least, is that Article 1 is the Declaration of Rights in the state constitution, which is Pennsylvania's analog to the Bill of Rights. And what that means is that if you look at Section 27, is it means that unlike almost every other state in the country, Pennsylvania citizens have a right to a clean environment. This is really unusual. The Article 1 contains our right to free speech, right to freedom of assembly, right to bear arms, and other rights, but it also contains environmental rights. And the environmental rights that it contains fall into two sort of broad categories. And you can, if you look at the sentence, the three sentences in front of you, you can see how it's laid out. The first sentence gives us a right to clean air, pure water, and the preservation of certain values in the environment. That's one right. The second and third sentences are different in kind. They involve public natural resources, and they create a public trust for all people, including generations yet to come, in the conservation and maintenance of those resources. Now, the one other thing I want to say before we go to the next slide is that the rights in Article 1 are rights as against the government. The government cannot take these things away from you. And when we talk about that, that's important because they're not necessarily rights against private sector folks operating all by themselves. These are things that are rights as against the government, and they create corresponding duties for the government. Next slide, please. So thanks to John Smith and others, and John, of course, will be speaking in a few minutes, the Pennsylvania Supreme Court made a landmark decision in the year 2013. And the most practical consequence of that decision for the conversation tonight is that it means local zoning matters again. Act 13 of the law that was passed by the General Assembly in 2012 basically took away from local governments their ability to determine where oil and gas operations could take place. And the Supreme Court said that that was unconstitutional. Now, 3 justices decided this based on Article 1, Section 27. And you might think, after I just summarized Article 1, Section 27, well, how hard can this be? But the reality is that for more than 40 years, another Pennsylvania court decision from 1973 basically minimized the role of Section 27. The courts held for more than 40 years that Section 27 they ignored the text of Section 27, and they said that what it really means is this 3-part balancing test, which people challenging government actions almost never succeeded using. And so when the Supreme Court said, hey, we're going to use Article 1, Section 27, and we're going to pay attention to its text, that was a landmark thing, as obvious as it sounds, when they did that in 2013. Now, the Supreme Court has 7 justices. And only 3 justices, Chief Justice Castile and 2 others, signed on to the plurality opinion about Article 1, Section 27. But that plurality opinion laid out in enormous detail in a very eloquent, thoughtful, and memorable way how Section 27 ought to be interpreted and applied. And the reason we got to 4 votes, however, on the decision to hold the parts of Act 13 on local zoning unconstitutional is that a 4th justice, Justice Baer, said, well, I'm not comfortable with Section 27, but I do like substantive due process. And so you got a decision that raised Section 27 for the first time ever, really, as a source of authority for holding a statute unconstitutional. But it took more than 40 years to get there. Next slide. The deal really got finished in 2016 in a case called Pennsylvania Environmental Defense Foundation versus the Commonwealth. And here you had a clear majority that said that the text of Section 27, the text of the Constitution, Section 27, means that the legislature cannot take money from the public trust and divert it for other purposes. And what basically happened here is you have an oil and gas leasing program on state lands, which are public trust lands. And you have gas, particularly, that is being taken from shale. And again, a public trust property. and is being sold on the market, which is fine, according to the court. But what this Pennsylvania General Assembly was doing was taking that money, or at least a great deal of it, and saying, well, let's use this to balance the budget. And the Pennsylvania Supreme Court said, no, you can't do that. If you're going to take oil and gas from public natural resources and sell it, you've got to take the money that you make from that, the royalty money in particular, you've got to take the royalty money and use it to conserve and maintain public natural resources. And so it was with this particular case that the Section 27 really truly became the law of the land in Pennsylvania. Next slide. Now, what the Supreme Court did in both of these cases was explain a bit what the first part of the amendment and what the second part of the amendment mean. And I want to share this with you because this has some fairly substantial relevance to what local governments can do and should not do. The first sentence, the court says, places a limit on the state's power to act contrary to this right. So, and by the way, when we talk about the state, the court is pretty clear that we're not simply talking about the state government, meaning state agencies. We're also talking, just state agencies, we're also talking about local government, because local governments to some degree are part, well, not to some degree, local governments really represent state authority in many ways. So if you take that first sentence in the second bullet, this clause places a limit on the local government's power to act contrary to the right. And laws that unreasonably impair that right are unconstitutional. So that's the first sentence, and that gives you a hint of what this means for local governments. Next slide, please. So the second and third sentences, the public trust language, as I've indicated before, involve public natural resources. Surely state forests and parks, oil and gas contained in shale. And then they say the people, including present and future generations, are the named beneficiaries of the trust, which makes perfect sense if you think about it. But then it says, and this is important, all agencies and entities of the local government, both statewide and local, have this constitutional trust responsibility. And as Doug indicated, as I think John will be talking about, some local governments understand this, but a great many do not. Next slide, please. So what are the trustees' duties under the second and third sentences? If you are a local government and there are particular identifiable public trust resources for which you have responsibility, that could include public parks, state forests, or local forests, and any number of other resources. What exactly is your job? Well, to begin with is making sure that these resources are protected from diminution, depletion, degradation. That's the first thing that needs to be done. And the second thing is that, again, read this in terms of local governments. The local government must act affirmatively via legislative action to protect the environment. That's basically what these responsibilities are. Next slide, please. So that's the end of my part of the presentation. The one thing I just want to share with you again is that there's a lot of work to be done here, as John pointed out, but these are your rights. These are your rights to have your local government do. And now I'll turn it over to John.
Okay, thank you, Professor. And going back to the Robinson case, as Mr. Shields pointed out, the court in great length cited Professor Dernbach. He saw this issue. He saw how the application of this amendment should be in place years before the court was willing to do anything about it or had the opportunity. But again, my name's John Smith. Many of you on have already texted me, so thank you. I'll work with my lighting the best I can. But I'm currently solicitor for East Findlay Township and Peters Township. I have acted as special counsel for a number of different municipalities in drafting ordinances. I've also had occasion to challenge ordinances. I've been before the Pennsylvania Supreme Court on 3 occasions and the Commonwealth Court on numerous occasions over oil and gas ordinances. So I appreciate Mr. Shields asking me to come tonight. Before we walk through the slides, and I asked Robin to change them for me, I think you have to understand what zoning is to understand the interplay between these constitutional amendments and your obligations as local officials with municipal ordinances. And I get it. You are typically challenged with people that want drilling because they want the monetary compensation, and people that don't want drilling because they want their normal life to stay the way it is in the area where they purchased. So that is the great split amongst us. And I see it everywhere. This carnival can go from town to town. It's the same issue, same people. You're taking my right to make money. You're taking my right to live in a quiet and have enjoyment in my neighborhood. So how do we get there? Well, under Article 1, Section 1 of the Pennsylvania Constitution, that's where you need to start as a local official, because you don't have the right necessarily to put anything you want in any zoning district. But it's gotten lost over the years because we just look at zoning districts and forget the constitutional underpinning of how zoning districts work with the Constitution. So essentially under Article 1, Section 1 of our Pennsylvania Constitution, the very first one in our Constitution is the notion that you can do whatever you want with your property, right? Do with it as you please. Now it's modified here in the quote cited by Justice Barron as concurring opinion, but don't use your property so you don't injure your neighbors. Understand though, what zoning does is zoning in its purest form is an infringement on Article 1, Section 1, because zoning limits what you can do. Local governments limit what you can do. So how does that work? Why is it that zoning does not violate this constitutional amendment, the very first one in the Pennsylvania Constitution? Because zoning has been determined to be a proper use of the police power. So local governments, state governments have the right to use their police power to protect people. And zoning is a tool that can be used to protect people so long as it uses compatible uses in like districts. It doesn't expose certain areas of the town to incompatible ideas, and why we have these plans that we put together, these comprehensive plans that work. So when a municipality, and I tell this to every municipality when I come into town, I wasn't the one, and I typically believe you weren't the one that decided your zoning districts. Residential, commercial, industrial, somebody decided that these are areas where we want to group these like uses. So if we could turn the slide. This is from the Commonwealth Court, and where we argued, and the law is still good law. An en banc panel of the Commonwealth Court in 2013, striking down the state law, held that zoning ordinances segregate industrial districts from residential districts. And you segregate these noises and odors necessarily incident to the operation of the industry. And if you look at this 3304 section, the court recognized that you just can't take an industrial application, with Mr. Shields alluded to earlier, and place it anywhere you want. You have restrictions. Because in order for zoning to work, to zoning to not violate Article 1, Section 1, your due process rights, it has to protect you. And you see in here in the definition section of compatibility. Well, the courts recognize that if a use is not compatible, you think about it, residential areas, why we don't have steel mills, as alluded in the slide, why we don't have cement factories in new areas. It's not because it's great zoning and great ideas. That's part of it. But it's also because it would violate the Constitution. It would violate Article 1, Section 1, because you're not using zoning at that point to protect people. You're using zoning to facilitate compensation. That's not something that is authorized. If we could turn the slide. Here is a case, and we get out of the Robinson case, and I know I only have limited time, but a lot of municipalities now have looked to this Frederick versus Allegheny Township Zoning Hearing Board case as a replacement for Robinson 1. It is not. And I bring this up because a lot of solicitors, and I speak at other events with my fellow solicitors, and they take a different read of these decisions. But what I just said, what the court looked at in Robinson 1, the Allegheny Township Court in deciding that Allegheny Township could really allow drilling in all these zoning districts and not violate Article 1, Section 1 was because they redefined or recast and characterized what our case was about. This court's Robinson 1 substantive due process analysis is not applicable here because it addressed Act 13's deprivation of municipalities' ability to determine the placement of oil and gas operations. Wholeheartedly disagree with that. And you need to understand that because you will be confronted when you draft an ordinance with this case. You need to pull this decision, understand that's not what it was. This was not a fight about local versus state, who gets to decide. The local governments we represented were absolutely on board with a state law that did not violate the Constitution. And allowing drilling in all zoning districts violated Article 1, Section 1, in addition to Article 1, Section 27. So in light of that, that's why we challenged it. What the court has morphed this into is the municipality's ability to determine the placement of oil and gas operations. True in part, we do have that, but we have the same controls before. This isn't unfettered. You don't get to pick where it goes because you have pressure or you think there's a big open field in a residential district. The residential district has been zoned for a specific purpose, and there is a definition as to what is residential. Drilling is not one of it. So be aware of this case. This is the case that's out there that has been used all the time by municipalities that want to go beyond allowing drilling in industrial districts, and that's in my municipalities where we like to see it. Slide, please. This just goes on in terms of the Gorseline case. Now, this was the last case we really saw the Pennsylvania Supreme Court. They've looked at other oil and gas related issues, and we don't have the time to go through all of this, but be mindful of the Gorseline decision, because in Gorseline, there was drilling in a RA district. It was allowed, I believe, as a conditional use, and this was one of those catch-all provisions. They didn't have an ordinance that provided for it, so the ordinance itself fell to this catch-all provision. The court struck down the granting of conditional use allowing drilling in a residential district. And the reason was primarily is the court looked at the purpose of the zoning district. I guarantee any of you that have access to your zoning ordinance right now can go online, pull up your book, and you will see the purpose of your residential district, the purpose of your commercial district, the purpose of your conservation districts have absolutely no fit and nothing to do with drilling or industrial applications. So the typical ordinance provides for that the purpose of the zoning, the purpose of the R1 district is to have happy homes and nice streets and friendly people, and it goes on and on and on. So municipalities have to ignore the purpose of the district in order to move into these areas that are otherwise barred industrial applications. And that's, again, going back why we believe and why the courts have held, especially in Robinson, it violates Article 1, Section 1, because it's not compatible with the district. But beyond compatibility, the definition section, the purpose of your zoning district, defines what you can and can't do. The municipalities that follow it are looking to the expectations of their citizens and making sure that when you buy a home, the purpose of the district is fulfilled. By contrast, municipalities that say, well, if we don't allow drilling in the residential district, some of our people won't make money. They have to ignore the purpose of the district, and for me, have to violate the citizens' constitutional rights. Next slide. Now, this was a provision that we did use in Robinson for a number of different reasons. Article 3, Section 32 of the Pennsylvania Constitution. And it's not been kicked around lately. I have a case now that it's going to go back up to the Commonwealth Court. But be mindful, you cannot create special laws for one industry. So when you're drafting your oil and gas ordinance and you look at your residential district, your commercial district, your business district, and your industrial district, and you look at all the uses that you've already laid out what can go in those districts, and you decide you're going to create an oil and gas ordinance that allows oil and gas alone to come outside of that industrial district, and it is an industrial land use as defined by the Supreme Court multiple times, and you're going to let that industrial use out and say, okay, every other industrial use, you must stay in the industrial zoning district. But oil and gas, you get to go out. Why? Because our citizens can make money, and we think that's a good thing, and we're not going to comply with Article 1, Section 1, or 27. But no one has taken back to the court until I have recently Article 3, Section 32. You cannot create special laws for one industry. And so you say to yourself, are we letting anybody else out of the industrial zoning district? And if we aren't, then aren't we creating the special law in violation of Article 3, Section 32 of the Pennsylvania Constitution? And the only way you look at this is, what if you allow drilling in an industrial land use, and I come in and say, well, you know what? I have a cement factory. I'd like to come in too. You're like, well, no, you can't. We're just letting them in. So two things have happened just in that little sentence. One, I'm showing you that I'm treating somebody special, which we're not allowed to do. And two, now I have equal protection claims because I have to treat everybody the same. So why am I treating one industrial use better than another industrial use? Next slide, please. Along those lines, what we're also seeing, and I bring this up about Section 605, is we're seeing overlay districts, right? So municipalities have, in fact, drafted ordinances recognizing that they have these future residential districts or future commercial districts. They're not built out yet, but somebody decided from a planning standpoint, let's take this 200 acres and zone it residential. Well, now drilling comes to town. They look at the industrial zone, and almost universally, if you look at your ordinances, most industrial areas are very small because municipalities did not want industrial applications in their towns. They recognized they had to have space for it. So typically it's the smallest zoned area, not always, but typically. So here, people start to use in municipalities overlay districts. So let's overlay the residential district and let's create an area where we will allow drilling in part of the residential district. So I bring up 605 because under 605, and remind you too, not everybody calls an industrial district an industrial district. Some refer to it as business district. You're gonna have to look at the labels that are utilized, but typically you look at the list of what can be done in that district, and very clearly you'll see whether it's residential, whether it's industrial. Now here, 605 says if you're gonna have a zoning ordinance, you better have uniform uses in respect to that district. So here you have this residential district, and you're going to use an overlay to overlay this 200 acres of proposed residential land in the future to allow drilling because it's a big open space and it's away from everybody. So under 605, our argument is that you can't do that because some people in the residential district that purchased will have greater protections than other people in the residential district. And the MPC 605 speaks to that and doesn't let that happen. Next slide, please. Here is the definition of an overlay district. Purpose of an overlay district is to create a specific and targeted provision that can serve natural resources and development objective without unduly disturbing the expectations that created by the existing zoning districts. And they supplement the existing districts, they do not supersede them. So what does that mean? Typically when we see legal overlay zones, we see maybe a town of Pittsburgh or Philadelphia excuse me, that looks to overlay a historic district. So here you're giving greater protection to that part of the municipality or the city. We're going to create a historical zone to give protections. It doesn't change the underlying district, doesn't change and supersede it. It just gives greater protections. Here you are saying we're going to use an overlay to eliminate a residential portion of the district and allow for industrial. You are in fact superseding the underlying zoning district. That's an improper use of a overlay. Next slide. This is where we are at the end, and I want to thank again Professor Dernbach and Mr. Shields, and I know we have some questions, and sorry we had to speed through this so much.
And I'll join back in, and thank you both. Actually, we're right on time. We're just about a minute and a half or so behind. But we have some interesting questions already popping up from our audience, and I wanted to toss one at you. This goes to the injection well matter, and an injection well is a subsurface activity is what the question is being posed. So a municipality can ban that, correct? Do they have to allow all surface operations such as frac ponds and so forth? Those are two kind of separate things. First of all, I'll pose this question to both. Can you ban an injection well just because it's subsurface? Actually, I kind of know the answer, but let's get to that part because everything starts at the surface and the fracking occurs below. But So we'll go from there. John, Solicitor Smith.
Yeah, I think number one, an injection well is going to have a surface application in your municipality. It's impossible. Otherwise, you might have some bleed over from another municipality. And I also wanted to point out along those lines of the oil and gas companies know your ordinance is better than you do. So if we see all the time, if you have a stronger ordinance, they will maybe go to the neighboring municipality. If you have a weaker ordinance, they will use your municipality to drill the other municipality, so that the other municipality doesn't have all the pain and suffering of the surface activity. But can you ban it? I think there is case law in Pennsylvania that you can ban it if you can show that it's harmful, a noxious use, and that's where I would go with injection wells. And I think, Doug, you pointed out earlier, you better have an ordinance that speaks to that,
right.
Because if you don't, you might have less argument to make that it shouldn't go in this particular area. Professor, you have anything on that?
No, I think that's fine.
And going to Professor Dernbach, the Supreme Court in Robinson said, and I'm going to quote, "This court has held that a political subdivision has a substantial, direct, and immediate interest in protecting the environment and the quality of life within its borders, which interest confers upon the subdivision, the borough, the township, standing in legal action to enforce environmental standards." Professor, can you speak to that issue about the subdivision having, you brought it up in your talk, and thank you for doing so, but you run into people and go, that's not my problem. That's the federal or state comes in and takes care of all that. How does a local official, what burdens are imposed upon them in the context of making any law, whether it's a zoning law or any ordinance for that matter? But in this context, it says the subdivision has a substantial, direct, and immediate interest in protecting the environment. So if I have a state law that counter that, you have a couple of options. One, as in Robinson, you can bring suit. What other options do you have, and what kind of obligations are imposed on that local official once they raise their hand and take the oath of office?
Well, I'm going to give you an outline of an answer because there's a lot packed inside the question you just asked. I think a starting point is recognizing sort of the historic role of local governments is to protect public health, safety, welfare, and morals. It's the police power. That's and whatever's within the four corners of that is fair game historically and has been for a good long time, certainly at least since the Euclid case. Just about a century ago, where the United States Supreme Court made that pretty clear. But I mean, I think you start with the police power, and then I guess the question is, well, how are you going to exercise the police power? And the most thoughtful answer and the shortest answer I can give is you want to exercise the police power in a way that's consistent with your constitutional duties. And so it's not like, oh, well, the Constitution is out there, that's the state constitution. If a local, I'm in the Harrisburg area, and there's all sorts of litigation about whether local governments can regulate the various aspects of gun use. And there's all these right to bear arms questions that come up. So of course, at the local level, you've got to comply with the state constitution. And with respect to Article 1, Section 27, I think the questions to be asked in any given case are, does this involve clean air or water? Does this involve the preservation of the natural, scenic, historic, and aesthetic values of the environment? Does this involve public natural resources? If it does involve public natural resources, are we conserving and maintaining them? If it involves public natural resources, are these resources over which the state also has some obligation? If so, then what is our relationship with the state, and how do we handle the fact that we are co-trustees with the state on these resources? And those are all questions I think that need to be asked. On a lot of matters, Section 27 isn't going to come up, but on issues where the answer to those some of the questions that I've asked is yes, well then I think some additional work needs to be done. The one other thing I would say, just quickly then, the one other thing I would say is that we often think of Section 27 as something that stands alone and is separate and apart from all of the other stuff that goes on in zoning or environmental regulation or whatever you happen to be doing. But more and more, I think people see that you can build Section 27 analysis into what a particular municipality is doing under the municipality's planning code, how you design your comprehensive plan, how you build your zoning ordinance. All those are issues where Section 27 can have some influence, and where more particularized local regulation can actually go a long way toward assisting in the implementation of Section 27.
I have a follow-up question to that, Professor Dernbach. And that is the lands held in common piece of this. And we went through a little bit of that with Franklin Park when they were contemplating the land being leased out, no surface operations. They were going to get somewhere in the neighborhood of $300,000 as a bonus payment for the lease, and then a royalty of some amount over time. Are you saying, based on the Supreme Court decision, that the funds derived from the trust, the park, the land held in common, then has to be plowed back into the park? It can't be used to pay for the gas for the police car. Is that what we're saying here?
I do not see a way to escape that conclusion.
Okay, very good. Thank you. I got that right. And then again, we also went through the several years ago, the Allegheny County executive here, pretty big supporter of fracking in general, also leased out a county park. So that revenue now, I'm not sure exactly where that revenue is flowing, but are you suggesting that that should go back into the specific park that it was taken from, Deer Lakes Park, which is in the northern part? The county runs a number of county parks and regional parks, and that was the only park that they ended up leasing. So would that have to go back to the parks in general, the park system, or would the funds derived from that have to be restricted for use at Deer Lakes Regional Park?
An issue similar to that is before Commonwealth Court right now, and I'm not sure that there's a clear answer to that question.
Okay, so but again, it's about, I'm going to cash in the public trust to pay for operating expenses or pay down debt service or something like that. Now I get a sense that that's really getting into a potential, that you may get sued by your citizens at that point if you are going to, and that's kind of what happened in the Supreme Court in the Environmental Defense Fund case, which I'm not sure if our audience is aware of that in that case, where basically the royalties coming to the state from leasing out state parks, state forest lands were going to the general fund. And my reading of that case was those dollars were derived from the trust and they have to go back into the trust. And so basically I use this, I said, well, you might have gold-plated park benches in the park, but you've got flat tires on your bulb tires on the cop car. But that's a problem too, because a number of municipalities have already looked at that possibility. And the other thing that municipalities, I think you touched on this, are in fact, and it's worth repeating, are in fact a part of the state. While the Environmental Defense Fund case said this is all about the state, of course, local government is a subdivision of the state, so it applies to them the same. Would that be correct?
Yeah,
okay.
That would be correct.
And moving right along with some more questions, John, I should say Solicitor Smith, what happens to a municipality when they have, you mentioned something in your talk, I see it constantly. Oil and gas is a conditional use exception in all zoning districts. And that's true in a number of these South Hills communities that we're starting to work with. That was true in Monroeville before they changed their code and restricted it to their relatively small industrial zones. How does that all work? How does that all work out? What causes of actions do we have if our municipality decides to go do, run off the path, so to speak?
Yeah, and typically, Doug, what you see is just in general a challenge to the ordinance, right? Mm-hmm. There's a challenge that, hey, you're running afoul of Article 1, Section 1, maybe Article 1, Section 27, or it also alluded to where what other industrial applications are allowed in all these zones? Is it just drilling? How does that work with the special law provision. You can't create special laws for one industry.
Mhm.
So that's what we typically see. We're probably going to see more of a reverse taking at some point if you have a residential area and you have a valuation drop because of a certain issue, and you've allowed this application, this industrial use into the residential district, and either something happens to your home or it knocks the price down. At some point, the court's going to have to address that issue. And I wanted, before you move on, just to touch base with a question you asked the professor on the environmental, I think, obligations that the local officials have. And what we don't talk about a lot or enough is Section 3303 of Act 13 preempted local governments from dealing with environmental matters. That is the province of the state, and that's how it works. And the court struck that down. And that's where you were getting to. The court said, not only is that unconstitutional and that needs to go, but local governments, you have an obligation to make sure that the Environmental Rights Amendment is fulfilled. So you can't look idly by, and because the constitutional rights are your citizens and you are a government, and you can take no action that will affect their rights. So what we see at the local level, a lot of municipalities saying, well, the DEP say it's fine. I've done, I don't even know, 20 conditional use hearings for oil and gas. And now, just out of pure sport, I asked the question, you'll have volatile organic compounds and hazardous air emissions from your site. Yes. Do you know what they all are? No. Do you know how far they will travel? No. Do you know whether they'll harm these people? No. They don't even fake it anymore. They tell you straight up. So local municipalities that think that the DEP is somehow policing this and that they wouldn't authorize this, that's not their job. DEP is looking to see how much pollution levels go off, not where they go, who it will affect.
Thank you. That's pretty important. I have another question here. Let's see. What happens when you don't have an industrial zone? We ran into this in Franklin Park, and we only have about 4 minutes or 3-4 minutes left. You want to jump in on this one? Franklin Park doesn't have an industrial zone. They wrote a letter to the governor and their representatives in the assembly saying, hey, this isn't working. Where do you see this crashing coming in? Professor Dernbach, I see this conflict of law where the municipal planning code says I have to allow for all uses, all legal uses in my municipality. On the other side of the coin, I have to deal with what John's talking about, incompatible uses. What happens if I have a municipality that has no industrial district at all, or, as you pointed out, a relatively small one that's not going to be able to host that? And then all of a sudden you find yourself violating the fair share doctrine in exclusionary violations of exclusionary rule in the municipal planning code, but now you're in conflict with the MPC, the municipality's planning code, or now you're in conflict with the Constitution. What happens to a place like Franklin Park Borough that has pretty much residential? Fox Chapel, three zoning districts, big houses, real big houses, and really, really big houses, and then they have a conservation district. They don't even have a commercial zone. How do you deal with that? What would be the legal prescription for this?
I expect John has seen that before, and I'm going to let him answer that.
Okay.
So we always pick on, unfortunately, Mount Lebanon, because we always say, where's Mount Lebanon going to put drilling? Do you have to accommodate them? Like everybody else, so typically, even if we have a municipality that's zoned with all these zoning districts, industrial districts, and it's completely built out, are you supposed to make space for them somewhere else, but not everybody? Because that's usually one of the issues we see. Mm-hmm. Now, the risk you run, and we see this more in the red light districts, right? Most municipalities have red light districts because they don't want adult bookstores and strip clubs somewhere in a municipality. So they all went and said, if you put it somewhere, then at least you're protected if somebody ever applies for it. So the fear is the curative amendment, right? The curative amendment statute says if you don't allow this use, we can put it anywhere. But remember, curative amendment is a statutory being. I've always wanted to challenge, and maybe it'll happen where the professor and I will do this, is another statute. If it says you don't have an industrial zone, so we're going to place it anywhere we want under the curative amendment statute, doesn't that statute then run afoul potentially of the Constitution? And that would be ripe for challenge. So I think these municipalities, there's a lot of deference by the courts given to their makeup of their communities and how they want to be. But it is a risk that you don't have an industrial zone, not just for drilling, for everybody. But what if you're already built out and that decision happened 60 years ago? We've not seen a case come down forcing somebody to create one.
Thank you. And I'm going to turn this over. Robin's got a couple additional questions from the audience as well. Go ahead, Robin.
Great. Thank you so much for this presentation. It's gone above and beyond, and we are so grateful to have you both tonight. Just a quick couple questions here. One has to do with leasing the land underground. So there was a lot of talk already in this presentation about Franklin Park, where they turned down a lease underneath one of their parks. They want to know if there is a possibility. We know that zoning deals with surface activity, but regarding subsurface activity, is there a zoning ordinance or an ordinance per se where they are allowed to prohibit the leasing of public lands, such as that, like prohibit leasing their mineral rights underneath their parks?
What we typically see, and I'll let the professor speak to this if he has an answer, but what I see typically is we don't regulate the subsurface, and not in all, because we do see these injection wells dug where we would want to regulate the subsurface potentially. Are there things that are going to make sure it stays within the confines of where it goes? But for municipalities, what we look at and say, okay, just because you are not coming on the surface doesn't mean that you are not an important part of this drilling unit. And would the unit go forward in the absence of your inclusion? And so if the answer is no, then maybe you are facilitating a drill site in another zoning district that's unconstitutional. So, you know, putting aside the idea of whether you're not coming on your land, but the prospect of they're still drilling in another area of town that would violate any number of our constitutional issues or ordinance issues, and you as a government are an enabler of that, then that's a question that we raise all the time.
Okay, great, thank you. This is an interesting one. With Representative Turzai leaving office, do you feel like there is a legislative window of opportunity for new legislation or greater action by the General Assembly of the governor's office to maybe enact restrictions on fracking between now and the election? I know that's
Professor,
kind
any thoughts?
I know it's a loaded question.
There's a tea leaves quality to this question, and I think the answer is maybe.
Could be.
Mm-hmm. Okay. Great, thank you. Do you have any advice on maybe how to best deal with a municipal solicitor that you feel might be friendly to oil and gas development? You know, when they should be required to recuse themselves, for example?
Yeah, I mean, it comes up. I mean, it comes up because we see that oftentimes maybe their law firm represents oil and gas interests. And we have ethical obligations if there's any appearance of impropriety. You know, so those are typically, we're governed by rules already to make sure that we don't put ourselves in a conflict situation. It's not always easy. That is one where I don't like the answer when these constitutional questions would go to the ballot box. But that is a ballot box question because, as Doug knows, the elected officials decide who their lawyers are.
Mm-hmm.
True enough. Yeah.
Great.
Robin, I have a quick question for Professor Dernbach. I was just trying to keep on track on time, but the constitutional piece is a bit of a mystery. And to some extent, there's not a lot of technical support for local officials on this particular matter. I've looked DCED pages, township supervisors associations, that kind of thing. Not a lot out there. Where would a local government official best find his way to answers about what their obligations are in this context in the Constitution? You know, it's hard. You know, that's kind of what we do to some extent, but where is the best place for a local official to go in order to really become familiar with the provisions that were brought down in the Castile decision in Robinson?
Well, there's a fair bit of writing that has been done about Robinson Township and PEDF. There's not been a whole lot that has applied that to local governments. And unfortunately, what you get is there are people who argue that Section 27 will stop anything you don't like. Okay, and there are people who argue that Section 27 means nothing or nearly nothing beyond what the Supreme Court has said. And if you think I'm making that up, you need to talk to some of the people that I've talked to. And so the question you're asking is a terribly good question. And that is, if you simply follow out the Constitution, you know, what do you get and what do you see? And I've been thinking for a long time that somebody needs to develop some kind of an explanatory resource, but I haven't seen it yet. And maybe in some post-webinar world, unless John knows of something I don't know, in some post-webinar world, that might be a project for John Smith and me.
And there are people, Doug, I think, that have tried to do this, have tried to like explain the application. And if you want to know about Article 1, Section 27, Professor Dernbach has written more than any of us will ever know, and it's current. He keeps, you know, updating and making applications. But I will tell you, the easiest application that I see at the local government level is, I think what Professor Dernbach, one of his slides, pointed out is you need to know in advance before you act what the environmental consequences are. So how many municipalities have created setbacks that have no earthly idea as to whether those setbacks will work or not? And the problem with that is, if you look at the case law, any municipal official on the line will know that once you pass an ordinance that says 500-foot or 600-foot setback, there's a presumption that that is protective of public health. So when the applicant comes in for their conditional use and they show a 600-foot, you've put the burden on yourself as a municipality, because you've already made a law that's presumed to protect public health at 600 feet, completely unsupported, and you put the burden on any objector to undo what you've done. So be weary of just picking a number out of thin air. And Doug, you alluded to, there are studies and literature out there you can gravitate to say this is a number that could work for your municipality, not feasibility of more drilling.
Yes, and on that note, I did ask a notable, he'll remain nameless for this, no sense in doing anything other than that, but he, you know, I asked him directly, I said, well, how did you come up with 500 feet when you did Act 13? And he said, the industry gave it to us. I wish I could get him under oath and have him say that. But, you know, there was no substance behind the 500 feet, none. And I remember when I was a councilman, when they were working on this and I wrote letters to them, oh, impact fee, what are the impacts? Oh, setback, give me what you utilized to determine how that setback number was arrived at. And of course, I never even got an answer. But that's where the setback is. And I think that's an incredibly important piece from the legal perspective for the solicitors and any planning commission people watching tonight, is that, you know, that setback better have a basis to it.
Right, or you're acting arbitrary. And so here with Article 1, Section 27, we want to make sure your right, my citizens' rights to clean air is not affected. I just picked a number out of the blue, and I have no idea, but the consequences of it is it'll be used back against you from industry in their applications. See it all the time.
Robin?
Right, wonderful. Thank you so much. I apologize, we did run a little bit over. I wish we could get to everyone's questions. Thank you all to ask questions and did not do it anonymously. So since we have your names, we'll be able to follow up with every question that's being asked. Thank you both again so much, Professor Dernbach and Solicitor Smith. What we're going to do now is take a quick 5-minute break. And we will have a little poll question that will pop up in addition to my screen. So if everybody can just come back at 7:55, that is 7:55. We'll see you soon. Thank you all so much.
Thank you.
Good night, gentlemen.
Good night.
All right, everybody, welcome back. Hope everybody had a good break in between. We are going to be starting up our next section here of the webinar, which will be the health aspects of fracking. Might sound a little catch-22, but here we will study the health effects, including setbacks and consequences, and why we are saying that zoning is such an important aspect when protecting your health and community. First, let me introduce our next panel, starting off with our moderator, with Dr. Patricia DeMarco. Dr. DeMarco is a native of Pittsburgh, PA, with a doctorate in biology from the University of Pittsburgh, and she has spent a 30-year career in energy and environmental policy in both private and public positions. She is a Rachel Carson Scholar and served as Executive Director of the Rachel Carson Homestead Association and Director of the Rachel Carson Institute at Chatham University. She holds the office of Vice President of Forest Hills Borough Council and sits as Secretary on the Board of Trustees for Phipps Conservatory and Botanical Gardens. Besides being an accomplished scientist, Dr. DeMarco since 2016, I'm sorry, I already said that part. Her book titled Pathways to Our Sustainable Future, A Global Perspective of Pittsburgh, explores positive pathways towards sustainability based on 28 case studies in Pittsburgh. She is also the executive producer of a documentary film with Mark Dixon, The Power of One Voice, a 50-year perspective on the life of Rachel Carson. Starting now with our panelists, we have Dr. Ned Ketyer of the Environmental Health Project. Dr. Ketyer earned his bachelor's degree from the University of Vermont and his medical degree from Northwestern University Medical School. As one of the founding physicians of Pediatric Alliance, Dr. Ketyer has served as president from 1997 to 2004 and has worked at Pediatric Alliance since 1990 and is the editor of the popular pediatric blog, the Pedia blog. Love it. Alrighty. As a consultant at the Southwestern Pennsylvania Environmental Health Project for the past 3 years, his primary role involves reaching out to health professionals to raise awareness about health effects linked to unconventional natural gas development in the Marcellus Shale region. Dr. Ketyer is also a board member of Physicians for Social Responsibility of Pennsylvania for the past year, reaching out on issues such as fracking, air pollution, and climate change. Next, I would like to introduce Sarah Rankin, public health nurse of the Pennsylvania Environmental Health Project as well. Sarah has received her BA from Penn State before completing her Bachelor's of Science in Nursing from the University of Pittsburgh. She worked as an oncology nurse and nurse manager at UPMC Shadyside and Hillman Cancer Center for 9 years before completing her master's in public health through the University of Florida. Concentrating on epidemiology and environmental health during her graduate studies, Sarah completed an internship with EHP during the spring of 2018, and we are so glad to have her. And last but certainly not least, we have Laura Dagley, Medical Advisor Coordinator for Physicians for Social Responsibility. Laura Dagley is a registered nurse and the Medical Advocacy Coordinator for Physicians for Social Responsibility. She has worked in hospital, home health, and hospice settings, where she began to connect her patients' health to their environmental exposures. She has worked with nonprofits in the region addressing health threats from the oil and gas industry. She now works in Pittsburgh with PSR as an advocate for healthcare providers, their patients, and the environments they live in. All right, with that being said, I believe, Dr. Ketyer, you're going to start us off for the evening?
Wait, I have like 2 minutes to open, please. I really think it's important that we think about the importance of the health of our communities when we're looking at our zoning regulations and at our laws that we make at the local level. Because really at the local community level, you are the closest to your citizens and the effects that they experience are right among your own community. And I wanted to just open with a thought from Rachel Carson. You know I can't do a whole thing without Rachel Carson, right? It says,
I'm not mad at that.
in spite of the truly marvelous inventiveness of the human brain, we're beginning to wonder whether our power to change the face of nature should not have been tempered with wisdom for our own good and with a greater sense of responsibility for the welfare of generations to come. It's one of these issues that just because you can do something doesn't mean that we should. And I like to keep in mind that the only reason slick water hydraulic fracturing is even going on is because the National Energy Act of 2005 gave exemptions from 7 environmental protections and health and safety protections for the public and workers in order to even permit this to happen. And so I have been skeptical about the validity of this industry from the very beginning. And now we have close to 30 million people in the United States living within a mile of hydraulic fracturing facilities. So understanding the health effects and the fact that air and water do not respect state boundaries at all, it's really important to understand where we are with the effects on children, on sensitive and vulnerable populations, and on communities, environmental justice communities, who are going to be taking the burden of these effects from this industry. So with that, Dr. Ketyer, I believe you're going first, and we look forward to hearing your presentation.
Thank you. It's nice to be here. I'm glad everybody is on this webinar. Let me just share my screen with everybody, and here we go. Okay. So again, it's very nice to be here with you to talk about these health issues surrounding fracking. We saw this map before in Doug's presentation at the beginning. This is what fracking in Pennsylvania looks like. About 12,500 active shale gas wells in the state. And you can see them with the purple dots on this updated frac tracker map. Most of the activity is in northeastern and southwestern Pennsylvania, and almost all of this has happened in the past 10 years. The green dots show where several hundred compressor stations are that move gas through the pipelines, and the yellow dots indicate where violations have occurred so far. And some of these violations have been criminal, as we've learned recently in the news. So about 1.5 million Pennsylvania residents live within a half a mile of shale gas infrastructure, and about 300,000 children attend daycare or school within a half mile of this industry. 10 years ago, when fracking really took off in Pennsylvania, there were a couple, maybe a handful of wells on each well pad, but today there can be dozens of wells on the well pad. Certainly most communities that allowed fracking in their municipalities back in the day didn't see these super well pads coming. They also weren't aware of all the other infrastructure involved in extracting and moving and processing shale gas. Fracking is inherently dirty and dangerous, and industry rules and regulations can't fix that fact, especially when the precautionary principle is ignored. Laura is going to show us in a few minutes that there is a growing body of medical evidence highlighting the potential public health harms from fracking. But even when there is scientific uncertainty regarding the links between emissions, exposure, and disease, there is still an ethical imperative to prevent harm rather than just treating it when it happens. It's the responsibility of municipal governments and residents to be informed by science in order to protect themselves from toxic neighbors like the shale gas industry. Harmful pollution is generated at every point of fracked gas infrastructure, from the teeming diesel truck traffic servicing super well pads that hold, like I said, dozens of wells on them, and the toxic and radioactive waste that's generated from the wellhead and is disposed of in landfills and injection wells, where even more pollution occurs. Pipelines scar the air, the landscape, and occasionally leak, spill, and explode. Compressor stations emit copious volumes of air pollutants like fine particulate matter, ozone-forming nitrogen oxides, cancer-causing VOCs, radon gas, and more. Pollution continues at gas processing facilities before the refined hydrocarbon is sent to local cracker plants. And a large amount of it, we should remember, goes to distant countries with an insatiable appetite for single-use plastics. And this activity, let's keep in mind, is happening where people live and where children play. Sarah is going to talk to us about setback distances in a few minutes. The well pads and the pipelines, the compressor stations, the shale gas refineries, or the cryogenic facilities are all operating around where children go to school. This is the Fort Cherry School campus in Washington County, kindergarten through 12th grade. It's now surrounded by 5 fracked gas well pads. The closest pad that you can see there on the left is 900 feet from the school's driveway. That's 900 feet from the only entrance and the only exit into and out of the school campus. And it's happening around where children play. And I don't think there's any parent, and certainly there's no pediatrician, who would look at this photograph and say that this is in any way acceptable. Let's remember also that most emissions coming from fracked gas and petrochemical infrastructure are invisible. You probably know someone, maybe yourself, who fits on this list of people who are most vulnerable in your community to environmental degradation and pollution from fracking. It shouldn't surprise anyone that women and children would be at the top of this list. Pregnancies can be complicated by prematurity, low birth weight, small for gestational age, babies, and birth defects. And all of these have lifelong consequences for the infant as that infant grows through childhood into adulthood. The health risk to infants and children living near shale gas development is especially concerning. As you have probably heard and you probably know, children are not little adults. Their behaviors and interactions with the environment increase their risk of exposure to toxic chemicals. If you've ever observed children, you know that they spend a lot of time playing outdoors in the dirt or the grass where the pollution settles. As you probably have figured out, they usually don't wash their hands before they put dirty toys and even food into their mouths. Their bodies grow and develop very rapidly, making their organs and body systems more susceptible to damage from toxic chemicals. Some of these chemicals discharged during fracking operations act as endocrine disrupting chemicals. That's really a problem for children as they're growing. It affects their growth, their development, and there are studies that show that cognitive and brain development are also impacted negatively when they're exposed to these endocrine disrupting chemicals. And children have a long shelf life, and that means that they have many years to decades after exposure to develop symptoms of chronic disease and cancer. So we should all remember, again, that poor health in childhood increases the likelihood of poor health in adulthood. Older people and those with limited financial resources are also at risk, as are people of color, who often live in environmental justice zones close to polluting industries like this one. Residents who have existing medical conditions like chronic lung disease, heart disease, kidney disease, and mental illness, and children with asthma are at higher risk for having exacerbations of those diseases. Fracking jobs are dangerous jobs, and industry workers are at high risk, especially for acute injuries, exposures, and illnesses. And we shouldn't forget our first responders. In the US, the shale gas industry is not legally required to disclose the chemicals that they're using when fracking. And this secrecy puts first responders at a disadvantage when called on to respond to an emergency. And it puts their health and their safety in danger. People who live near frack gas operations report many different adverse health symptoms. In 2017, EHP published a study looking at the health symptoms of adult residents living within 1 kilometer of a well pad. Sleep disruption is often the result of nonstop truck activity, noises, odors, and light while the well is being drilled and fracked. Headaches and throat irritation are also widely reported. Stress and anxiety are side effects of living near fracking sites. Some of these symptoms look like nuisance symptoms. But for people, when they're exposed to this day in and day out, week in and week out, and for the super well pads with literally dozens of wells on them, year in and year out, when they're exposed to that much industrial activity, these acute symptoms of exposure and stress can become chronic medical problems. We know that children and adults living near frac gas operations are sickened by the industrial pollution and by more than 170 chemicals used in the fracking process. No fewer than 55 of those chemicals are known to raise the risk of cancer in children and adults. Radioactive fracking waste is another major concern that increases the risk of cancer. From 2008 to 2018, in 4 heavily fracked counties in southwestern Pennsylvania, David Templeton and Don Hopi at the Pittsburgh Post-Gazette uncovered 27 cases of Ewing sarcoma, which is a very rare and frequently fatal bone cancer of childhood. And they also found 40 cases of other rare cancers for a total of 67 rare cancers in children, teenagers, and young adults, again, in these 4 highly fracked counties in southwest Pennsylvania. In Washington County, where I live and work, there were 6 cases of Ewing sarcoma and 30 cases of other rare cancers. These numbers are far more than would be expected to occur in a similarly populated area over a 10-year time frame. New cases keep popping up, and parents and physicians are very concerned that pollution and toxic waste from fracking operations may be to blame for this outbreak of rare childhood cancers. Last November, Laura Dagley and I had a chance to be at the State House with dozens of concerned community members, and we had the chance to speak with Governor Wolf and other lawmakers to demand a thorough and transparent investigation into the cause or causes of these rare pediatric cancers. 4 days later, Governor Wolf announced the creation of 2 studies to be conducted over a 3-year period by the Pennsylvania Department of Health. But here we are 7 months later and in the middle of a global pandemic, and we're still waiting to learn about study designs and timelines. The good news, hopefully, is that Sarah and Laura have a meeting scheduled this coming Friday with Secretary Levine at DOH to go over our concerns. So we wait, and as we wait, we watch the Shell cracker plant get built in Beaver County. This petrochemical plant, one of the largest ever built anywhere, will crack that fracked gas and make millions of tons of nurdles to manufacture more single-use plastic, which is one thing that nature doesn't need any more of. And the pollution of the air and the water will only increase as a result, endangering the health of everyone. And if we zoom out from southwest Pennsylvania, we can see on this frac tracker map the extent of the plan to transform the upper Ohio River Valley into a brand new industrial hub for fracking, petrochemicals, and plastics, and what many of us fear will be America's next cancer alley. Now I'm going to turn it over to Laura Dagley, Medical Advocacy Coordinator for Physicians for Social Responsibility, Pennsylvania, and Laura will talk more about the health impacts from fracking.
Hey, thank you, Dr. Ketyer. I'm just gonna share my screen. Okay, so I'm just going to repeat a little bit and reinforce some of the health impacts from fracking that Dr. Ketyer mentioned. And I'm going to reinforce them with the research that there is behind it. And while I'm going to be referencing a bunch of studies and statistics, we should remember that there are real people behind these numbers. There are actual lives and families who are impacted. It's important not to forget that, but I believe it's also important to know that there is research and data to support their stories. So don't let anyone tell you that the science just isn't available or that we do not know enough. There's actually a lot of research and data around fracking and its effects on health. It has been compiled and summarized in the compendium of scientific, medical, and media findings demonstrating the risks and harms of fracking. And this was put together by concerned health professionals of New York and Physicians for Social Responsibility, which Dr. Ketyer and I are a part of. It is a compilation of news investigations, government assessments, and peer-reviewed research articles. It was called the most authoritative study of its kind by Rolling Stone magazine. And the compendium was created to be accessible to public officials, researchers, journalists, and citizens, and the many Americans who now live within a mile of a fracking site and are going to be most susceptible to the impacts of fracking on their health. As the slide shows, 84% of the original studies looking at health impacts found that there were health harms related to fracking. And after reviewing all this material, the compendium editors concluded that by stating, there is no evidence that fracking can operate without threatening public health directly or without imperiling climate stability upon which public health depends. That's a very important statement to remember after a review of literature on the subject. And I'm going to go over a handful of the emerging trends, the main themes that show throughout the compendium, but note that there are many more that I won't have time to get to today. So Dr. Ketyer mentioned many of the common health symptoms that are seen near fracking sites. And these are backed up by studies that were actually done in Pennsylvania. There was a study done in Washington County that found dermatologic and respiratory symptoms increased in frequency as distances between households and gas wells decreased. So there were more rashes and upper respiratory issues were seen in people who lived less than 1 kilometer from drilling and fracking operations. This study was important because it was the largest of its kind to date, and its findings were consistent with earlier reports. It's also significant because it references literature that demonstrates the biological plausibility between oil and gas activities and the health effects reported. So this means that the symptoms we are seeing are ones we would expect to see if a person is exposed to the kind of chemicals we know are released from oil and gas operations. Another study was done by the University of Pennsylvania and Columbia University. It found an association with drilling and fracking activity and increased rates of hospitalization in Pennsylvania. So drilling activity increased dramatically alongside inpatient admissions for people who live near shale gas wells. Cardiology and neurology inpatient rates were significantly associated with well density. Also, inpatient prevalence for cancer, skin issues, and neurological problems increased. And this study observed a control county that had no drilling activity during this time period, and there were no increase in hospitalizations noted. Fracking threatens drinking water. Cases of water sources contaminated by drilling and fracking activities are proven. EPA's assessment of fracking's impacts on water resources have confirmed specific instances of water contamination caused by drilling and fracking. And various pathways with which this contamination has occurred can occur through spills, discharge of fracking waste into rivers and streams, and even just underground migration of chemicals into drinking water wells. Independent investigations in Pennsylvania conservatively estimate that there are 1,000 water contamination cases linked to fracking in PA alone. Fracking is also a major contributor to air pollution and smog. So chemicals such as benzene, xylene, formaldehyde, and hydrogen sulfide are released into the air during oil and gas activities. These are the same chemicals that are causing a lot of the health symptoms that we are seeing. So they have their own respiratory and skin issues, but when they're released into the air, they react with sunlight and cause smog. And smog comes with its own host of health problems, including lung and heart issues. And as Dr. Ketyer mentioned, anyone with already pre-existing heart and lung conditions are going to be more susceptible to these impacts. And unfortunately, some of the strongest studies about health-related fracking effects have been related to pregnant mothers and their babies. And a lot of these studies were completed again in Pennsylvania. In 2017, there was a study of over 1 million infants born in Pennsylvania that found poor indicators of infant health and significantly lowered birth weights among babies born to mothers living near fracking sites. Another Pennsylvania study found a 40% increase in the risk of preterm birth among infants born to mothers who lived near active fracking sites. And a Colorado study found an elevated incidence of neural tube defects and congenital heart defects, while new studies in Texas and Colorado have found associations with infant death, high-risk pregnancies, and low birth weight. And as Dr. Ketyer mentioned, these have lifelong impacts for babies who are born with low birth weight. And just this month, actually, a new study was released out of California that found prenatal exposure to oil and gas wells led to adverse birth outcomes. And the study replicated similar findings of the study done in Pennsylvania, and also recommended a 1 kilometer setback distance. Radon is the #1 environmental cause of cancer deaths. And drilling activities bring this naturally occurring radioactive materials to the surface. And studies have shown that radon levels in Pennsylvania homes have risen since the fracking boom. And areas that are heavily drilled have significantly higher radon readings than areas that are not. And of course, we can't talk about methane without talking about climate change. Methane is a potent greenhouse gas, much more potent than CO2 in the short term. And earthquakes are a proven consequence of drilling. Again, there's a lot of evidence out there. Larger earthquakes have been proven to be caused by fracking in Texas, Kansas, and Oklahoma. Smaller, more frequent earthquakes have also been linked in studies. And this happens because when they take the pressurized fracking waste fluids and inject it deep into geological formations, they trigger the seismic activity. And we can't forget that this is an environmental justice issue, as many environmental health concerns are. Well pads and the associated infrastructure are disproportionately sited in non-white, indigenous, or low-income communities. And studies have found that these communities have much less say in the approval process when fracking comes to town. Dr. Ketyer mentioned the precautionary principle earlier, and public health decision-making uses the precautionary principle as a guide. It implies that the governing agencies have a responsibility to protect the public from exposure to harm when scientific evidence has found a plausible risk. And as I just outlined, the risks are real. There is a lot of research and data to back that up. And in an ideal world, we would say, well, let's just regulate this and make sure it's safe. But there is no evidence that this can be done safely without impacting human health. And there is plenty of evidence to show that regulations go unchecked and unenforced. And so the safest course of action for a community to keep a community safe is to keep fracking out of the community to begin with. And that is why many health professionals have called for a ban on fracking. In 2012, the American Nurses Association passed a resolution calling for a moratorium on fracking. And the Pennsylvania Medical Society followed in 2016. And this was based largely, again, on the body of research that's out there suggesting negative health impacts. And I've mentioned the compendium about 1 million times now, and the link at the bottom of the page, psr.org/compendium, is where you can find it, PDF of it, and download it and have access to all this data that I just referenced. Thank you.
Okay.
And, alrighty, wonderful. Next up, we have Ms. Sarah Rankin. Whenever you're ready to rock and roll, let's go. Unless you have any comments, Dr. DeMarco. I didn't want to.
I was just going to call on her to go.
Okay. Thanks so much.
Please, if you're on the audience, put your questions in the chat box. There's a QA and there are a few questions in there, but please put your questions there.
Okay, thank you all for being here tonight, and thanks to Robin and Doug from Food and Water Watch for inviting me to speak. My name's Sarah Rankin. I'm a public health nurse for Southwest Pennsylvania Environmental Health Project, and I'm gonna share my screen. Okay. So tonight I'm going to talk, Ned and Laura did a really great job talking about a lot of the literature surrounding the health impacts from shale gas development. I'm going to be focusing more on setback distances and some of the studies that have been done trying to evaluate what is a safe setback distance, or perhaps more accurately, what is not a safe setback distance. Very briefly, at EHP, or the Environmental Health Project, where I work, this is just a snapshot of our website, which gives you a little bit of an idea of some of what we do. We lease air monitors to community members living near shale gas development. I do want to mention this tool, a health impact assessment, is something that communities facing the prospect of fracking coming in can use. It's really a set of questions that any community should have answered before shale gas development comes in. So it's a challenge to both the industry and elected officials to get those health-based questions answered so that a community can make a fully informed decision. We also do things like translate the scientific literature for communities and health professionals. So I'm just going to talk, this will be quick, I'm just going to talk about a couple of studies. The first of which is a study done by McKenzie and colleagues in 2012 in Colorado. It was a risk assessment, and they actually measured air emissions in Colorado near shale gas development and found that, as you would suspect, air pollutant concentrations increase with proximity to oil and gas facilities, as do health risks. At 500 feet, which is the current Pennsylvania setback distance, from a well, levels of ambient benzene and alkanes increase the risk of neurological, developmental, and hematological health effects. And also, lifetime cancer risk exceeded the EPA's upper threshold level of 1 in 10,000. It was actually 8.3 in 10,000. So they concluded that 500 feet is not at all a protective setback distance when you're considering the health of the residents who live at that distance. And I want to just point out that that study used something called risk assessment, which not a lot of people are super familiar with, but it's not actually counting the number of people who have those health effects, but calculating from the levels of chemicals what the impacts would be. So they're looking back at things like animal studies and occupational studies at the specific chemicals that we know are harmful and calculating out from the levels of those chemicals what the risks would be. In 2013, Macaulay published a paper. He also measured air pollutants at 625 feet from wells, which was the West Virginia setback distance. He's out of West Virginia University, and he found particulate matter and benzene levels high enough to cause health impacts. He found wide fluctuation in levels, and those were impacted by local weather and topography. So that's to say that if you set air monitors at the same distance from a well, say 625 feet, around in a circle around a well, you're going to get very different readings at all of those monitors, because air emissions don't spread out nicely in a circle. They are, of course, impacted by wind direction and speed, and also topography of the land. So he concluded that 625 feet was also not health protective for those residents. In 2014, the University of Maryland conducted a study of the public health impacts of shale gas development, and this was prior to the state's ban on fracking. And based on air emissions and risk of explosions, they recommended setback distances of no less than 2,000 feet. Also, Marcia Haley in 2016 reviewed current setback distances used across the country from anywhere from 150 feet to 1,500 feet. And they concluded that none of these setbacks could adequately protect residents from risk of explosion. And they looked back at previous explosion incidents and found that the average evacuation zone was 0.8 miles or 4,224 feet. So they concluded that these setbacks could also not protect residents from radiant heat, toxic gas clouds, and air emissions. So based on those studies and also something called a Delphi study, which is basically a systematic attempt at getting expert consensus on setback distances, EHP has concluded, and while this is a little tricky because no one can truly say that a certain distance from shale gas facility will be protective of public health. It's basically impossible to say this, but based on the available evidence, we recommend a setback distance of at least 0.6 miles, which is 1 kilometer, or 3,281 feet. That is minimum for small facilities. So any small shale gas facility, like a small well emitting 100 to 500 grams per hour. For anything larger than that, we recommend at least 1.25 miles, which is 2 kilometers or about 6,600 feet. And that's for any larger facility like gas processing plants or compressors, and any facility that is situated near schools, daycares, hospitals, nursing homes, high occupancy buildings, which are housing vulnerable or difficult to evacuate populations. So all these things need to be considered. And this bar graph is basically just showing the difference between the current setback at 500 feet, which is number 1, our minimum setback for small facilities at number 2, and our larger setback distance for larger facilities at number 3. That's all I have. And if you have any questions on anything specific that I presented, I'd love to answer questions, or you can also go to our website, environmentalhealthproject.org, or email us at info@environmentalhealthproject.org.
Wow, well, thank you. This was an amazing summation of the impact that we're facing with this industry. And I am confounded as a scientist myself why we even allow this industry to proceed, and the evidence of harm just keeps mounting and mounting. We had a question about whether we are still facing the proprietary protection of what is being applied, what people are being exposed to. And I know as nurses and physicians, you might have to treat people who may not know what they've exposed to. What tools do you have to give you better information about what your patients or what our populations are being exposed to? Ned, do you want to take that?
Sure. You know, the job of a healthcare provider is to help the patient understand what's wrong and get better. And very often we get our information from the history that we take. And so historical information is so important. This is one of the first things you learn when you're a medical student and when you're a nursing student, I'm sure. And by taking a good history, it's important to understand what people are being exposed to. You take an occupational history, where do you work? A school history, where is your school located? Where is your house located? And you can go very deeply, and physicians and health providers should go deeply in the history. If you don't ask, you're not going to find out what people may be exposed to. All of us are used to asking about smoking. We're used to asking about diet and some of the harmful ingredients of food that we may be ingesting. But we have to go deeper, and we have to ask people, where do you work? Is there an industry near you? Are you near a highway? And here in Southwest Pennsylvania, you need to ask, where is your closest well pad? Are there pipelines and compressor stations near you? In my experience, most people don't know when you say, where is your closest well pad? And here we are in 2020, and people, they still don't know.
Yeah. Yeah, it's very frightening that you really feel like you're afflicted with this, situation, that we're just seeing it advance and advance and feel very helpless to do anything about it. I wanted to explore some more, Sarah, about the setback requirements, because most municipalities, including mine, and we have a 600-foot setback, because if you go beyond that, you'd be outside the borders of our town. And so we don't have standing to set standards, beyond the borders of our community. And I know that having even 1.5 miles is not far enough for some of these kinds of things. What kind of tools can communities rely on when they're developing a setback requirement, if they don't already have one, that might be helpful? I know your studies are very indicative, but what is readily available to municipalities as a rule of thumb?
Yeah, that's a great question. So when communities are looking to, find what tools they can implement to protect themselves, I point them to organizations like Food and Water Watch that have done this before, that have worked with communities to, either fight this or, implement safer setback distances. But as you said, a lot of communities are small enough that it's impossible to implement these setback distances. And I also know that a lot of the scientific literature is not available to people. It's behind paywalls and tough to understand. We have a couple of pretty easy to read pamphlets from EHP that, with the recommendations and where they come from, with our recommendations and where they come from. But yeah, as you said, a lot of communities are in a tough place with their size and not being able to really implement a setback distance like this. We present this information knowing that, this is in more of an ideal world than many people live in, unfortunately. But community organizing with groups like Food and Water Watch is always something that I recommend.
Okay, that's very helpful. And I think organizations that have collections of municipalities, the Allegheny County Boroughs Association, Connect, PA Municipal League, need to hear this information so that groups of communities can argue for better protections for these kinds of setbacks. Laura, we had a question about studies that may pertain to sound levels from fracking facilities. Are there any in the compendium that address noise ordinances or noise conditions that we should be aware of?
I don't, and maybe Dr. Ketyer also would know the answer to this question. I don't know if there's any specific to noise in the compendium. Dr. Ketyer, are you aware of any?
I don't know. I would bet, well, certainly if a study was done, it's going to be in the compendium. I think the compendium is really the go-to resource for questions like that, to go to the index and look. I mean, we know the effects of different levels of sound on health. Those studies have been done for decades. We know that you can measure the sound coming off of a well pad, for example, or near where trucks are idling, or where they're leaving their staging area and going to a well pad. We know the sound, what the sound levels are of a flare stack. So these things are measurable, they've been measured, and we know at certain decibels what the health impacts will be at certain distances. Now, I'm not sure whether there's been a study specifically looking at sound generated from shale gas infrastructure. the measurement of that, but I suspect it's somewhere in the compendium.
I'm looking at some stuff in the compendium right now. If you do download the PDF offline, you can do a search feature. There's a lot of information about noise and its general impacts on like wildlife, like birds, and just its stress impact. And one note about noise is the definition of noise is an unwanted sound. And so you can talk about decibel levels and how that can, we know that certain decibel levels can lead to hearing loss and other health impacts, but just by the definition of what a noise is an unwanted sound that can lead to stress, it can lead to loss of sleep, headaches. It doesn't really matter what the decibel level is for that to happen. And so that's important to note because chronic noise can lead to chronic stress, which is associated with a whole host of health problems.
It's true. And there are certain stages in the process where the noise is more acute, like when they're doing the seismic testing and when they're flaring and when you have the actual hydraulic fracturing, it can be quite unsettling.
And paired with the light and just the truck traffic, you know, there's just, it's the accumulation of all these things that really have the impact.
Yeah, we regulate in pieces, but you experience the effect as a summation of a totality of impacts. It's really quite overwhelming.
Yeah, that's a very important point.
Yeah, yeah. I know we've had some commentary about things that municipalities need to prepare for, and one of them is proper training and education of their first responders. Are you aware of any particularly valuable sources of training for police forces, emergency management people, and first responders who may be called, even if it isn't in your town, but to a local area to respond to these kinds of incidents?
That's a concern for me personally. My son is a volunteer firefighter here in Washington County. And I do worry about, I know he goes through an awful lot of training through his fire department. It's high quality training. You know, he goes through hazmat training, all firefighters do. So it's very important. I don't know if they actually do mock drills for you know, a fire on a well pad or an overturned truck, and what specifically they may come in contact with. But I do think they get good general training. Now, the concern that I have is that for a specific incident, there's not enough time to get specific information on what has leaked out of the truck or what is escaping from a ruptured pipeline. And that, I think, is very dangerous situation for first responders, not just firefighters, but police, for EMTs and EMS services. It's a problem. And I think that no amount of mock drills can really prepare you, I think, for a situation that's so physically dangerous. And it really worries me quite a bit.
I know there, when you have a regulated hazardous material, there's a placard on the truck, for example, but the exemption under the Resource Conservation and Recovery Act allows water that comes out that has all kinds of things in it to be just dirty water. So if you have a spill, you may not know what kind of volatile organic materials or radioactive materials or highly corrosive materials may be in that material that you're being exposed to. So this is a concern I've had with our own first responders, and I think we need legislation to address that because it is a serious hazard to people. We have a question from Ronsley. He says, knowing that the evidence is in as to the devastating health effects of fracking, what legal means have been initiated in the courts to stop this threat to public health, a threat that is poisoning the public? And it's exposing, like I said, almost 20 million people nationwide. What recourse do we have based on the science that we know well? Sarah, do you want to take that one?
I was going to say that might be a question better suited to the previous panel.
Yeah, I don't know if it's still on. Yeah.
We turn to them when we are looking for answers about legal recourse, for sure, but it's a challenge.
I find sometimes all the really sound science, peer-reviewed reports and so forth, they don't always have standing in the court. I know I have frequently given testimony myself and cited things that are peer-reviewed and highly well documented. And they're saying, well, that's just science. I mean, we don't know for sure that that's true. It's just the theory.
Yeah, oftentimes elected officials point to the fact that it's just observational science, which is extremely frustrating, especially given the fact that we can't put people in an experiment and test the emissions from shale gas. Of course, we would never do that. So we have to rely on the world as our laboratory to understand these health impacts. And, you know, I give all the credit in the world to the scientists that study these issues, because they're quite good at it and they control for all sorts of confounding factors. And get, you know, time and time again, statistically significant results and evidence of harm. And it's a real shame when that's brushed aside as just observational science.
And we shouldn't forget the fact that the oil and gas industry spends many, many millions, hundreds of millions probably, dollars creating doubt. And there was a great book by Naomi Oreskes, Merchants of Doubt, that really explains that quite a bit. And it's not just oil and gas. I mean, they did it with vaccines. They did it with acid rain. They did it with nuclear weapons. I mean, the list, tobacco. I mean, it's just the same playbook. And if they can come up with anything that to a layperson sounds like a plausible, denial, they will deny it, and they will create enough doubt. But the precautionary principle does not require evidence beyond a reasonable doubt. It requires plausibility, and circumstantial evidence is certainly acceptable to show plausibility of harm, and we should keep that in mind. I can't really speak about the legal things. That's like Sarah said, I think that's beyond our scope.
Great. Laura, did you want to add something to that?
I was just going to say that it's worth noting that historically we've not been able to rely on government regulatory actions to respond in a timely manner to the scientific studies. Like lead in gasoline is a perfect example. We knew that was bad. It took, I think, like 40 years before there was actually a law passed to prevent that from being put in gasoline. So,
well, this is a particularly frustrating situation because the exemption in the National Energy Act of 2005 is not widely known. That's why I bring it up every time I talk, because people deliberately knowing that you could not do this legally under the law. And we had a question from a person who asked, knowing that the evidence is in as to the devastating health effects of fracking, what legal means do we have to stop this threat to public health? I mean, we've not had good support from our lawyers and from our legislators to reverse what is now 2 decades of harm.
Yeah, I think the law is stacked against people that want to see this industry better regulated, and some people who want to see this industry go away. I mean, it is very frustrating. We do know a lot about the harms, and their inherent dangers. You're not going to be able to regulate these away. So I think it is frustrating, and ultimately, the best that we can do is keep learning about this, keep putting pressure on the people who we elect when we go to the polls, and hope that others will see it our way. I always think that when things aren't going my way, I haven't tried hard enough. And so you have to try harder, and I have to try harder. I think all of us have to try harder to convince people, again, using science and being respectful that people don't necessarily see things the same way, but we all have the same common sensibilities, and we all share the same common ground. We need clean air. We need clean water. We need healthy soils to grow our food. And we need a healthy climate system. And above everything else that we've talked about, fracking accelerates climate change. You know, we can talk about pollution, we could talk about benzene and particulate matter all day long, but the 800-pound gorilla in the room is climate change, and fracking completely accelerates that process.
I don't know if any of you, in your going around to talk to people, have encountered this really fatalistic attitude that having unhealthy working conditions or unhealthy industries is just the price you pay for good jobs. Have you encountered this philosophy in this area? I find it really heartbreaking that people feel that kind of fatalistic, well, you know, you're going to get sick if you have a good job. That's why you get paid. And a lot of these people are not paid as well as you might think. Have you encountered that? And what can we do to counter that other than promulgating the alternatives?
Well, that's an example of normalizing pollution. And in this country especially, our leaders, our industries, businesses, corporations have done a great job in normalizing pollution. There's nothing normal about emissions from fossil fuels, for example, poisoning little children, poisoning their lungs and poisoning their brains. That's not normal. It's not radical to call for a stop to this type of stuff. What's radical is allowing this industry to continue the way it is going. That's just, you know, it's crazy. I personally don't think that jobs that directly hurt people are defensible. And I don't think that we should be defending that at all.
Thank you. That's really important. Okay, we're coming close to our closing time. Is there anything anyone would like to add that hasn't been brought up yet? I think the fact that fracking and the entire petrochemical build out is going to be a tremendous blow to our efforts to contain climate change is not something to underestimate. The emissions proposed from just the single Shell petrochemical plant in Monaca will completely negate all the gains from the city of Pittsburgh P4 process, for example. And I know that it's one step forward and 3 backward, but we're out of time to be going backward at this point. So I would hope that we can take these kinds of really important findings and facts on the health effects that we're all experiencing and not perpetrate this. This is something that we do not have to do. We have better choices and we have better alternatives that will yield good jobs and good economies in our communities and a better future for our children. I worry tremendously about sending forward to the next generation these slowly spreading plumes of highly concentrated saline that have been pumped already into the ground, and they are not going to stay where they're put. We know this. Capillary action works, as last time I checked, and the diffusion of that plume may be very slow, but it is irrevocable. So we have already, you know, laid down a legacy that's going to be very hard to reverse. And I certainly hope that any community that has fracking trucks going through their town will see to it that we don't have dirty water used for dust control or ice control, because the radioactivity that spreads is just beyond belief. So anything anybody wants to add for the good of the order, and I'll give this back to Robin for closing out.
I just wanted to add, if anybody hasn't read Justin Noble's article in Rolling Stone that really addresses radioactive waste streams like you were just mentioning. So.
Devastating, very devastating. And if Don Hopi is still on, I want to give him a shout out and thank him for his diligent work in covering this issue. Okay, Robin, it's all yours.
Wow, that's all I can say is wow. I kept writing notes. No matter how long we've been in this, we learn something new every single time. And just one of those phrases that will stick with me forever is the normalizing pollution and defending jobs that hurt. Really and truly, it shows where industry's priorities are sometimes and where they're not. So I'm sorry, this section always makes me a little bit emotional, and I cannot thank you all enough for consistently bringing attention to these issues and never ever stopping the fight to protect what we have and what we will have, meaning our children and their children's future. I see the Q&A has pretty much filed out. Thank you so much for answering questions and elaborating. This has gone above and beyond, and I cannot thank you enough. Just to double check, we had several questions in the Q&A saying, will we be allowed to have the slides? Are people okay with sharing the slides in a PDF format, a protected PDF format? Great. So those will all be sent out in the follow-up email to everybody who has registered, along with the recordings to recording links to each webinar session. So if you have any further questions, please don't hesitate to contact either Doug or myself. And with that, I just want to say thank you, a million times thank you for all of your hard work, for your dedication, and look forward to more.
Indeed. I'd just like to throw a final word in. We got a couple of minutes left. One, I want to thank the panelists tonight. I want to thank all of our panelists, both on Saturday and today, this evening. It was our first effort, and I want to thank everybody behind the scenes at Food and Water Watch for helping. Also, I want to thank our funders, Heinz Endowments, Allegheny Foundation, the Pittsburgh Foundation, and others, also local contributors too, to Food and Water Watch. If you want to donate, we don't take any government money, no corporate money, so this all comes from you, and we really appreciate your support. But as you have seen and heard, we have seen this problem illustrated by planners on Saturday. We've heard from local elected officials talking about their experiences. And tonight we've heard from 2 expert attorneys and our wonderful health panel of health experts. There's a lot more to this. We wanted to give all of you a taste of what we're dealing with, and we want you to come back for more. This is not the be all to end all of webinars, and we are here at Food and Water Watch. Check us out online at www.Food and Water Watch. Look for the Facebook page, Food and Water Watch PA. There's always some news on that site about what's going on, and I'm sure you can find us easily enough. Robin, myself, and our other colleagues working here at Food and Water Watch will be more than happy to work with you and work with your local governments to get you protected, because until that state laws are changed and address the realities of what's going on here, this is all fallen into the laps of the local elected official by way of zoning and everything else, and you. It's your problem. This is the way the state set the laws up, and it all comes back to the local level. So you can define the character of your community, or you can do nothing and allow a corporation from Texas or somewhere in Pennsylvania begin to come into your town, and they'll define the character of your community for you. And I'm sure you're not going to be pleased with what you find. So once again, thank you. Robin, any closing remarks before we head on? Okay, well, thank you, everybody. And Patty DeMarco, thank you for being the moderator. Patty was also on Saturday morning as elected official. She's from Forest Hills. And here's the other thing. If you're not happy with your government, go look in the mirror. Guess who the government is? We are, we the people. So don't be afraid to step out, give voice to some rational thought here. Thank you.
Thank you all again. Have a wonderful and safe evening, and take care. Bye.
Thank you.
Thank you so much.
At your service.